Are you?
Contracts means like a legally binding oral or written agreement for individuals and business to sell or transfer property, service, and other rights from somebody to the other party. There are some important elements of contracts such as offer. Offer or proposal is an expression of willingness to contract to do or to abstain from doing anything with a view to obtaining the essence of the other to the arts. There are two types of offer, which is bilateral offer, means made to a specific person or group of persons. Unilateral offer means made to the world at large. For example, shopping center offer the product and services to customer. Invitation to trade. In my understanding, invitation to trade means some party invite the other party to accept the proposal or to reject it. For example, A invite B to buy the product. B have option to reject or accept to buy the product.
Now we continue with acceptance. Acceptance is the offeree's agreement to be bought and to be bind the offerer by the promise. Requirements of acceptance. First is acceptance must be absolute and unqualified. Second is acceptance must be communicated. Next is modes of communicating acceptance. First is acceptance by post or telegram. Second is acceptance by telex or telephone. Third one is acceptance by conduit. Fourth one is acceptance by performing conditions stipulated in offer. The last one is acceptance by silence.
Consideration. There are three types of consideration. The first is executory consideration, means in return for a promise, the other party give promise to do something in future. Second is execute consideration, occur when one of the parties has done all that he is required to do under the contract. It means that in return for promise, the other parties perform an act. Third, past consideration, occur when the promise is given in return for the act done. This type is consideration is not generally considered as a good consideration by English law. Must be distinguished from execute consideration, whereby in execute consideration, both the promise and act are integral and correlate part of the same transaction. In the past consideration, the promise is subsequent to act and independent. The requirement of consideration. The first, consideration need to move from the promise. Under to the contract act, a party of agreement can enforce the promise even if he himself and given no consideration as long as somebody has done so. Second is consideration must be sufficient but need not be adequate. The court will not concern about the adequacy of consideration. The court will enforce the contract as long as it proven that the parties that made deals regardless whether it is good deal and otherwise. There are situations. The consideration may are considered as insufficient. The performance exciting obligation. Second is part payment of a debt. 26 Contract Act provide the agreement made without a consideration is void unless it falls within any this. First, it made on account of natural love affection. Second, it promised to compensate or for something done. Third, it is promised to pay a debt bear by a limitation law. Natural love and affection. English law does not recognize as valid consideration. One of the other hand, Malaysia recognizes it as valid consideration as stated in S26 A Contract Act. Life certain prerequisites are complied with. Expressed in writing, register under law if applicable, and the parties stand in near relation to each other. Promise to compensate for something done. 2.6b. Provide an agreement made without consideration is void unless it is promised to compensate wholly or in part a person who has already voluntarily done something for the promiser, or something the promiser was legally compellable to do. In order for act to be done voluntarily, it must be done at the person initiative.
Legal capacity. In order to determine the capacity of the contracting parties, two factors were taken into account. First is X factor, two is soundness of mind. Age of majority, Act 1971, provided that a natural person must reach the age of 19 to presumed as a major person that has legal capacity. Hence, any contract entered into by one who has not reached the age of 19 is void. Effect of agreements entered by minors. Generally, under common law, all contracts entered into by minor are voidable at the option of the minor either before or after becoming adult. It differs according to the type of contracts. One is minor obtained. It is the interest of a permanent continuous natural. Example, interest in land. It is a binding until decreed by minor. Two is contract not continuous in operation. Example is promise to pay. It is not binding unless ratified by minor within reasonable time after reaching age majority. Unsound mind. The defined soundness of mind as a capability of the person to understand and to form a rational judgment as to effect to the contract upon its interest the time he makes a contract. Under common law in contract by a sound mind, a person can be reasoned if can be shown that one is at the time the contract entered he was incapable to understand his action. Two is in the party knew about it, meaning that contract is voidable.
Hello, Assalamualaikum. My name is RAFIDAYANAH. Now I want to explain about intention to create regular relation. Why it is important? It is because some agreements are not intended to be legal in force. It is one of the elements of information of contract, example offer, acceptance, consideration, and capacity. What is intention to create regular relation? It is intention of a party become legal bond with legal consequence to sue and to be sued. Then, how to determine it? An agreement will not constitute a binding contract unless it is one which can responsibly be regarded as having been made in contemplation of legal consequence. There are two relations, which is domestic relation and commercial relation. Domestic relation means where social and domestic relation are concerned, there is no intention to create legal relation. Commercial relation means in case involving commercial dealing, the mere fact that an agreement is supported by the consideration raise a presumption that the parties intend the agreement to be legal binding. However, it can be repeated if one the fact has been indicated otherwise. And then how we determine it? In order to determine whether there is any intention to create a regular relation, there is two ways. First, what is the nature of the agreement? It is social, domestic agreement, or commercial agreement. If domestic or social, they presume that there is no intent to create the legal relation. If commercial, it is presumed that the parties intend to bind one another legal. And the second, there is any evidence to rebut that above presumption? If no, the presumption shall stand. If yes, the presumption is rebutted and the result shall be contrary to the presumption.
According to Section 10 of Contract Act 1950, it is provided that all agreements are contract if they are made by free consent of the parties. Consent is said to be free when it is caused by one or more of the following. First is coercion. Coercion is the practice of another party to act in an involuntary manner by use of threat or force. Second is undue influence. Undue influence is an equitable doctrine that involves one person taking advantages of a position of power over another person. Third is fraud. Fraud is intentional deception to secure unfair or unlawful gain or to deprive a victim of legal rights. Fourth is misrepresentation. Misrepresentation is a false statement of material facts made by one party which affect the another party decision in agreeing to a contract. Last is mistake. Mistake is an erroneous belief at contracting that certain facts are true. That's all from me.
Unlawful and void contract. According to Section 2G Contract Act 1950, void contract is an agreement not enforceable by law. What agreements are void? Section 24 Contract Act 1950 provides that the consideration of object of an agreement is unlawful if it comes within the any 5 below. In each of the above case, the consideration of or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is lawful is void. Section 26. An agreement made without consideration is void unless it comes within the 3 exceptions provided. Section 27. Every agreement in restraint of the marriage of any person and other than a minor during his or her minority is void. Section 28. Every agreement which by anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. Section 29. Every agreement in restraint legal proceeding except for a contract agreeing to refer disputes to arbitration or a contract relating to scholarship is void. Section 30. Every agreement in the meaning of which is not certain or capable of being made certain is void. Section 31. Every agreement made by way of wager is void, exception in favor of certain price of horse racing. Consequences of void or legal agreements. The general rule: the court will not enforce an illegal contract out of an immoral situation and action does not